Yes.
Okay.
The case is now being recorded.
Okay, calling the sixth case for today, February 3rd, 23P1397, Department of Children and Families versus Mother. Just remind counsel that this is an impounded case, so no, let's not refer to anybody by name. Let's refer to them by description, oldest child, youngest child, however you want to do it. And we ask that when you're not arguing that you remain on the screen so we can make sure you're still there. Try to keep your gesticulations and reactions to a minimum because that can be distracting to the panel and to the other counsel. And with that, we'll hear from Attorney Perry Mercier for the mother.
May it please the court, Amy Perry Mercier on behalf of mother. This case is about a mother with mental health challenges who was never given the opportunity to parent. It's about two children who were never given the opportunity to be with their mother. DCF they assumed that because mother had mental health challenges that she couldn't be a parent. They assumed that she couldn't do this without ever giving this family a chance. They failed to follow both the federal disability law and their own regulations and policies, and they failed to provide mother reasonable efforts and accommodations. The court failed to decide on a timely basis anything about visitation and reasonable efforts, despite mother requesting in March of 2022, there was a motion filed on behalf of mother with regard to reasonable efforts. And the judge,
that motion and the papers around it were about the number of visitations, right? That had nothing to do with mental health services.
it didn't have anything to do with mental health services, but this was I think it was a theme throughout the case. Mother had filed various things with regard to services. I think that the issue here was that
she filed various things with respect to services. What did she file with respect to services?
I don't think it with regard to services, but with regard to the case itself. I think that the issue is there was never any assessment done of mother with regard to her mental health. And so the issue is that mother, according to DCF, wasn't making any progress despite being actively engaged in services, and there was no assessment or anything done in order to assist mother in determining why. And so that is the concern with regard to mother's accommodations. Mother may not have known what services were available due to her disability. And so the department, through action planning and through its own ADA process, never did an assessment of mother. Mother did an assessment on her own and filed it, unfortunately, right before trial. And so that assessment actually called for more assessments that could have been done in order to assist mother. And so the department, under its policies in 2022, did not provide any sort of assessment or individualized look at mother. In her action plan, for a short period of time, they had I believe, a neuropsychological, but that only lasted for 6 months, and that was a year prior to trial. There was no evidence in the record with regard to mother, the department providing mother a release in order to have such a referral made for a neuropsychological or a psychological assessment or a parenting assessment. There was nothing within the record that showed that they would that was even a possibility. There was an ADA meeting, but that ADA meeting really they did put in some of the things, but for example, one of the things that mother requested was a parenting partner, and that parenting partner left after 8 visits because of concerns of mother's mental health. And that wasn't a red flag to the department that perhaps maybe we should be assessing mother and finding out what additional services mother may need to be engaged in order to assist this family. And this isn't a mother, by the way, that wasn't involved in her action plan. They asked her to be involved in therapy. She was involved in therapy. They asked her to have a psychiatrist, and she had a psychiatrist. She was active in her
So
in
I'm
her
sorry,
Sure.
so they asked her to be
Okay.
involved in with the therapist and psychiatrist, and she was.
Right.
How is that consistent with your claim that they didn't provide her any services?
Sure. Well, I think that, in cases like this where a mother has significant mental health needs, it may not be the right type of therapy, right? So there's different types of therapy given the specific needs of the parent. So she may have not been getting adequate therapy or the right type of therapy. There may have been a recommendation for her to have different types of therapy or different volumes of therapy, but that was not explored.
Council, so on the ADA issue, so they did hold an ADA meeting, right, in July of 2021. And well, actually, that was postponed until November 2021 because mother got a new attorney. And then there were some recommendations made. And then in February 2022, mother's attorney reached out and asked for ADA accommodations, right? And so the department in response offered to convene another meeting, and then that meeting never took place because I think that neither the mother nor her attorney ever followed up. Is that right?
I'm not sure if it's because they didn't follow up. I don't know whether it was just, I think it was around that time that the reasonable efforts motion was filed. So I'm not sure what exactly happened. There's nothing in the record that says why it didn't happen, that it didn't happen. And so I think, but there were some things in the initial ADA meeting that weren't followed up on. I know that mom had said initially during her testimony that she didn't find DMH services helpful, but she was willing to engage in them. The department reached out, according to what we have in the record, once to DMH, and they never got a call back, and there was never any follow-up with regard to that. That we can see in the record from any of the social workers to assist mom in getting more services. So the only thing that really came out of that initial ADA meeting was a parenting partner. And that parenting partner only lasted 8 sessions, which I believe may have been a month or two at most. And so, again, these are issues where I believe during that initial ADA meeting, even the attorney had, I believe, requested a neuropsychological, but that was never even put into the action plan. The department, under its own policies and based on a settlement, is required to do assessments, is required to make an individualized assessment of what the parent needs. All therapies are not the same. They kind of assumed that mom had an issue with Adderall and she had a resulting psychosis, and there was really nothing to be done. And instead of making any sort of accommodations or efforts in order to try to reunify this family.
Can you help me with a factual question here? Early on in the action plans, there was a request for a neuropsych evaluation and a medication evaluation, which those do drop from the action plans. There's some evidence that she actually did undergo a psych evaluation, but didn't share the results. Can you comment on
That is what she testified to, Judge, but again, it is unclear, and there's no evidence other than her own testimony what it was. And so I'm not sure whether that actually happened or not. But that doesn't negate the department's obligation to do its own due diligence. Just because mom may have provided it on her own account doesn't negate the department being able to request, as is normal protocol in these cases, is to request a release and make referrals. It doesn't, just because she may have had one doesn't mean that the department can't ask for one to be done. So mother, was an active participant in this case. She had weekly visitation from all accounts, the visitations went relatively well. She asked for additional visitations. She asked for visitation in various locations, which, and the department just kind of shut her down because she wasn't making progress, but not giving any way for mom to make progress. She was asking for things like going to YMCA swim and gym or going to like a play group at the YMCA. And they said, essentially, so sorry, your mental health is too bad, but never, gave her any sort of way to move forward.
And I just, just to follow up on that, really the crux of this case really is mother's mental health issues, correct? And they were longstanding. There've been multiple hospitalizations, and close in time actually to when the trial began, and there continue to be criminal cases that mother picked up, right? Some OUIs and also violations for restraining orders. And even during the trial itself, there is evidence that the judge noted in his findings about mother's behavior during the trial, her inability to answer questions, and even some of her answers being at best non-responsive, and also explaining some of her behavior, talking about being hypnotized, and I'm not going to go on, but I think we're all aware of the extent of some of the concerning statements that mother had made, not just at trial, but prior to trial that she was asked about. So even up until that point of trial, would you concede that there continued to be concerns about mother's mental health?
I don't think that that's in dispute, that mom's mental health was the primary issue in the case. But it doesn't necessarily mean that there's a nexus, right? Adoption of Catherine that with parental ability, right? That doesn't mean that she can't be a parent just because she's got mental health issues. The issue is that can she sustain minimally adequate parenting? And what I'm saying is that the department failed to assess mother and to assist mother in services that they're required to do under the Americans with Disabilities Act, under the section of 504, and under their own policies in order to assist mother with her mental health to make effective progress towards ameliorating her mental health concerns. And that is the concern, right? What the department essentially left mother on her own, and it wasn't really clear that mother was not meeting the standards. They weren't doing anything to assess to show that she needed additional services. It was just that 6-month period where they had that neuropsych and they had that medical eval, and then it just dropped off. And there's no testimony, there's no evidence in the record that shows that they tried to do more in order to show that they were making these reasonable efforts towards mother being able to ameliorate her mental health issues.
Can I ask you a question about the mother had 2 older children who how did the not in her custody, were there adjudications on those 2, or how did that happen?
I believe they were with their biological parent, their other biological parent.
Does the mother still have parental rights with respect to those kids?
Yes. That's my understanding. Obviously, yes, subsequent to this case, I don't know what happened subsequent to this case, but my understanding is that they're in the permanent custody of their other biological parent. So mother, again, and I think, the department also had concerns with regard to the children's special needs. And so I think that's a relative term, what special needs are with children, but the only thing that they offered her, for example, was for her to have a Zoom with the pediatrician, and didn't allow her to attend in-person visits where she could visually, ascertain what these children's needs. And so I think that the department really kind of, with regard to mother, failed to provide her reasonable efforts and accommodations. And based on that, I would ask that this court reverse and to allow to have the department provide these reasonable accommodations and allow these children and this family to be able to figure out. It may be that, you know, mother's mental health may not be able to be ameliorated, but we never had the opportunity to find out one way or the other based upon, you know, the department's inaction.
And seeing no more questions, we'll ask you to mute yourself, but stay on, please. And we'll hear from DCF.
Thank you, Your Honor. So mother—
Pronounce your name again. It's Golke?
Golke. Yes, Attorney Golke. As we heard, mother does not meaningfully contest the unfitness determination, but rather is seeking to have the termination order overturned on the ground that the department did not provide adequate accommodations. But she acknowledged in her brief that binding precedent from the SJC in the cases of Gregory and Ilona foreclose either reasonable efforts or the ADA as a defense determination. And the reason for that is the juvenile court judge is required to consider the best interests of the child as paramount, even above the interests of the parent. And their role in a termination proceeding is to determine both the unfitness, whether it is temporary, and then the best interests of the child. And that's precisely what happened here. But even looking at the content of mother's claim that the department didn't offer either reasonable efforts or accommodations, sort of depending on the framework, she isn't able to point to any accommodation that was requested, but that was not provided. So what happened here is the department did make reasonable efforts to reunify this family, and unfortunately just was not able to see the kind of change that would be required to make that a possibility. And the juvenile court found that mother's non-cooperation in terms of sharing information with the department really hamstrung the department in being able to offer different services than the ones that, you know, it was already providing. So it was providing referrals to therapy, it was providing referrals to psychiatrists, and mother was using some of those services, but mother was refusing to share, to allow that information to be shared with the department, either by not signing releases or by signing releases with certain notations, crossing things out, writing under duress. And there was testimony from her therapist that her therapist, as a result of those changes, her therapist did not feel comfortable sharing information with the department beyond attendance.
Which therapist was that?
That was Susan Matina. So that was her current therapist at the time that she'd been seeing for about 6 months at that point.
Because, I mean, maybe I looked at the wrong part of her testimony, but she testified that the mother did allow her to discuss treatment goals and progress.
So she had said, let me just find where this is. What she had said was that she was able to confirm attendance. And then at trial, she did confirm a treatment goal of building a trusting relationship, but that she hadn't been comfortable sharing that with the department social worker in the prior communication that the department had with her, because she said she was unsure about the legal status of the release, and that she had spoken with other people at, I think, in the legal counsel's office of her own practice, or it may have been other practitioners. But
I know you hate questions like this, but can you tell me where in the record that is?
Yes, I do have it, and let me just see where I put it. That's the question of where I wrote that down.
Would it be in your brief with the specific?
I believe so, yes.
Not unsure about the legal status?
Yeah, it is the last, she was the last witness. So it would be toward the very end of the trial transcripts.
So it's in her testimony. It's not a document. It's in her.
Correct. It's in her testimony.
That's good enough. That's
Correct.
good enough. Let's not.
Yeah. So it's in the trial transcripts, and I believe there is a citation in my brief to that. I hope. But yeah, she testified to that. And then in terms of the evaluations, a neuropsych evaluation or medical evaluation, mother testified in her own testimony at trial. She did not think further evaluations would be helpful. That's at transcript 322. She also testified at transcript 268 that she believed her mental health was, quote, fine. So in her view, she didn't believe that there needed to be more evaluation. And, you know, understanding that mother was herself in a difficult mental spot at the time, but the indication was that she was not willing to cooperate with the department on further services. And even her expert, who both submitted a report and testified, and I believe this appears in both, but certainly in the written report, said, in his opinion, further referrals by the department would not be helpful because mother had such distrust in the department. That was an expression of her mental health, in his view, that she would not benefit from services that were referred by the department, that she would really only benefit from services arranged through her attorney or arranged through her current care team. And so it's very difficult to see, you know, what more the department could have done in this situation where it was ensuring that mother was in therapy, it was ensuring that she was getting medication from a medication provider, but it was unable to get that many details about any of those services that have been offered, and wasn't able to engage with mother on further services, or, you know, in the view of her expert, that just simply wouldn't have been helpful. And from the juvenile court's perspective, hearing all of that testimony, I think it's quite reasonable and certainly not an abuse of discretion for the juvenile court to find that there just was not a reasonable likelihood that she would be able to attain fitness under these circumstances in any kind of foreseeable future. And under the case law, you know, that supports the juvenile court's decision to order termination here. Even if, you know, there may be some further treatment available to her, she may still make progress. Certainly that would be everyone's hope, that she could continue to make that progress, but that doesn't prevent the juvenile court from making a determination in the best interest of the child to terminate parental rights. And the juvenile court did recognize, you know, that mother loves these children. No one doubts that she does have a connection with these children. And the juvenile court did order post-termination visits in recognition of that. So certainly I think that the juvenile court was sensitive to the fact that mother would really love to be able to provide care for these children, and unfortunately just wasn't able to see that as a realistic possibility under the facts of this case. So I'm happy to answer any questions the court has.
So in the earlier action plans, they required a neuropsych evaluation and a medication evaluation, and those elements dropped from later plans. Was there an explanation of that?
There is not anything in the record about that. There is, you know, the testimony that mother said she did do the neuropsych exam, but then didn't provide it to the department. I will say that so there are 3 action plans over the life of this case. That was the first one from February 2021, has those 2 evaluations. The later 2 action plans are very similar, and they do have that she meet with a psychiatrist and take medications as recommended, and of course that she meet with an individual therapist. So while the evaluations themselves are not on those action plans, there are action items aimed at, you know, improving her mental health and seeing if she can make progress on that. There also did appear to be discussion of those plans at the ADA meeting in November of 2021. So that was during the sort of life of the second action plan. So although they didn't appear on the next action plan, there was discussion with between the department and mother about whether she would be willing to do those and then sign releases for the department to consider the results. And she repeatedly testified, you know, that she signed all releases under duress, that the social worker testified that she did not receive any evaluations along those lines. So we don't know precisely why they dropped off, but it did not appear that the department completely dropped them as sort of ideas of trying to work with mother, but it did not include them on the later plans. And if the court has no further questions either on the ADA or reasonable accommodations arguments or on the underlying unfitness determination, the department would rest on its brief.
None. Thank you. And we'll hear from Attorney Gerova-Wilson then.
Yes, good afternoon, Your Honors. Attorney Gerova-Wilson. I represent the 2 children. My clients are currently 4 years and 3 months old. They're twins. They have lived in their kinship pre-adoptive home since their birth. along with the family's two older biological children. The twins have heightened medical and developmental needs, requiring them to go to frequent medical appointments from the Berkshires to Boston and to receive attentive care daily. The record is clear that all of their needs are being met in their pre-adoptive home. They're healthy and happy in the only home they've ever known. They're asking today that the judgment terminating their mother's parental rights is affirmed.
I'm going to ask you a question. The kinship placement. Who is the kin with? What is that relationship?
I can explain to you, Your Honor, but I'm not sure if it's actually in the record. If it's important to you, I can tell you what the relationship is.
Is it on mother's side or father's side?
Mother's side.
Okay, thanks.
A lot has been said about mother's mental health. And it's indisputed that she unfortunately suffers from delusions, disconnect from reality, and at times psychosis. The judge noted in his findings that the mother has diagnosis of adrenal misuse disorder, causing psychosis, as well as bipolar disorder and schizoaffective disorder. She has been hospitalized involuntarily multiple times, making her, if anything else, unavailable to care for these two young children. So the judge made no assumptions about her ability to care based on preconceived notions of her disabilities. She was not there when she's hospitalized. She was not there to care for them. Similarly, in terms of her criminal behavior, substance misuse, she has misused Adderall to the point that her psychiatrist stopped prescribing it. She tested positive for cocaine and admitted to using LSD, but then at trial, she pled the fifth, basically, and refused to testify, and the judge made the finding that she indeed has used LSD. She has been unable to abide by multiple abuse prevention orders that the fathers of her two other children had against her, as well as the pre-adoptive parents. She continued to reach out to the fathers and to the children who are also subject to the abuse prevention orders. And when she was asked how many times she has been arrested because of those violations, she was unable to answer. She said there are too many to count. The record indicates 16 violations of harassment prevention orders between 2019 and 2021. And she even at trial testified, well, I guess I'll keep continuing to be arrested because I'm not going to stay away from my children. That was her answer to the question of, when she was questioned about her violation of those prior orders. So her being in custody, of course, again, if nothing else, makes her unavailable to care for the twins. Now mother claims for the first time, really, in an appeal that DCF has failed to exercise reasonable efforts by failing to accommodate her disabilities under ADA. I'm not going to go into details about why is that claim factually inaccurate, because the DCF already did that. But I would like to know two things. First, that issue was not preserved for appeal. The judge made no specific findings in terms of what ADA accommodations were made because they were not challenged. Even though she made a claim that there were no reasonable efforts, you cannot, it's very clear on the adoption of Astrid that you cannot present a trial and argument on one grounds and then argue another on appeal.
No, that's true, but I mean, the entire reason her parental rights are terminated is because of her mental health and substance abuse problems. And I mean, so isn't that an issue that, ran through the case that, that DCF did sort of have, even if she didn't raise it, that was the whole thing? Yes,
this is correct, Your Honor. And I really only have 1 minute. And I just wanted to mention that the most important argument against overturning the judgment is that under adoption of Gregory, it is not a defense to termination. ADA violation is not defense to termination of parental rights because those proceedings are not services, programs, or activities protected under the ADA. The law is very clear on the adoption of Gregory. Mom is not even arguing that the facts are distinguishable from that Supreme Judicial Court case. And again, this is the overarching concern that the welfare of the children is paramount. The mother's rights under the ADA, as important as they may be, are secondary. And the child's interest in freedom of abuse and neglect is absolute. And this is the case here, Your Honor. My clients have been in their placement for a long time, their entire lives, and it is very clear and undisputed that their best interest is to be adopted. Well, it's my mother disputes that, but and I ran out of time. May I have another 10 seconds to wrap up?
10 seconds.
As mother did not even allege that the trial court abuses discretion in finding it's in my client's best interest to be adopted by the current placement, I ask on their behalf that the judgment terminating the parental rights of their mother is affirmed.
Okay, seeing no more questions, thank you all. And I know that there were some issues that required us to be on Zoom, and I just wish wish you the best in resolving those issues. And with that, we'll be adjourned.
Thank you, Justice Massing. Again, I apologize for the inconvenience of the login